Dear students, today we are going to discuss the topic pleadings generally, which is envisaged in Order 6 of the Civil Procedure Code 1908. Please remember, pleadings are the statements drawn up by each party, maybe the plaintiff or the defendant, stating his contentions during the trial, what his contentions will be during the trial, and giving all such details to the opposite party to make his defense. This is simply we can say it is the definition of the pleadings. Of course, it is not there in the CPC. So that's why I am telling the definition part, of course. So please remember, there are 18 important rules, out of which we will discuss only the important 18 rules, out of which we are going to discuss only the important. Rule 1, pleading shall contain the so-called plaint and a written statement. That means the pleadings will be there in the plaint as well as the written statement. Rule 2 says, plead facts, not evidence. So if you mention the facts, that too in a concise form, brevity is more important. Brevity of the facts is more important, and you need not say the legal position, or you need not submit the evidence. If you plead the facts, it is sufficient. That's why I told you facta probanda and also facta probentia. So facta probanda is itself sufficient. That means please plead the facts. Facts which need to be proved, they are called material facts. Facta probentia, it means facts by which a case is to be proved, that is evidence. So facta probanda is sufficient for you. So it should, facta probanda should form part of the pleadings, and they are called the material facts. The material facts on which the plaintiff or defendant relies, definitely they must be stated in the plaint or the written statement, right? Okay. Then rule 6 is more important. Condition precedent. So if there is any condition precedent, just like the conditions that you will get 10 crores of property if you marry my granddaughter. So when it will come into force, if you marry the granddaughter. So if such condition precedents are there, then they should be given in an elaborate form. This was stated in the case law, famous case law, S.A. Henry versus J.V.K. Rao, 1972. Right, please remember rule 7. This is just like constructive res judicata. So departure. So if you plead one thing, you cannot depart it and file a new ground of claim or any allegation of the fact which is inconsistent with your pleadings. This is more important. So suppose if you file a suit for fixation of the boundary, okay, but you in the same time you cannot file a case of recovery of possession except misdemeanor profits, you know all these things. Then if there is any contractual obligations, all these things, you must mention the brief facts and enclose the contract. That's more important. Then if any documents are there, you have to mention, according to rule 9, you have to mention the effect of the documents. Effect of the documents itself is sufficient, right? And please remember, according to rule 13, there should be no presumption of law. Presumption of law will be taken up by only the court, right? Now, Rule 14A is newly amended. Now, Rule 14 says that the pleading should be signed. Rule 14A says that where you have to give the address of the defendants for service, and you have to pay the service charges, all these things, you know. Now, coming back to it. Rule 16, striking out the pleadings. Here, the discretion of the court comes into existence. Striking out the pleading. Even though you fill the plaint or written statement with so much of pleadings, the court is authorized to strike out the pleadings which are, number 1, unnecessary. Number 2, which are scandalous. Number 3, which are frivolous. And number 4, which are vexatious. So I told you the case of Mr. Narendra Modi. So somebody, that Tej Bahadur versus Narendra Modi, where the Honorable Allahabad High Court, it was requested to strike out the pleadings at the outset itself. So in the plaint filed by Mr. Tej Bahadur, so since the pleadings are unnecessary, the pleadings are scandalous because he wanted to scandalize the office of the Prime Minister of India. So they have to be struck off. Of course, Honorable High Court has done it the same. Because at that time I told you that High Court is the jurisdiction court, or High Court is the as original jurisdiction to try the case of election petitions, right? So please remember, if the pleading is unnecessary, vexatious, all these things, definitely the court can strike out the same. So the authority of the court is definitely wider, as stated by Justice Salmeshwar in the famous case of Ajay Arjun Singh versus Sharadendu Tiwari, 2016. This is regarding that Madhya Pradesh elections, that Chaurat assembly. One is a returned candidate, another came out successful. In that case, they are very clearly stated. So the very purpose of the striking of pleadings, this rule is to ensure that the parties to a legal proceeding are entitled to ex debitio justice. So to have the case presented against them in an intelligent forum. So this is rule 16, please remember. And now coming to rule 17 and 18. Let us club both of them. Rule 17, what does it say? It says either parties, maybe plaintiff or defendant, they can amend or alter the pleadings, at any stage, right? At any stage, please remember, already I told you, the stage means before trial, before the pre-trial and during trial I told you. So before the formation or framing of the issues, it will be better for the amendment. After that also, if the court thinks that it is necessary, it can allow you to amend, but normally they will not allow. So rule 17 says the pleadings can be amended because we are not that intelligent, error is common. For example, I tell you, A filed a suit for permanent injunction over a property, right? D has occupied against B. B has already occupied the land as a trespasser. Now, an amendment may be pleaded that he may be dispossessed also, is it not? Already the suit for injunction has filed. Since he is already under unauthorized occupation, he can be dispossessed. Like that, you can amend the pleadings. Rule 18 says, if the time is given for amendment within the proper time, you have to amend the pleadings. If you don't do it, or if no time is fixed, the period is 14 days. Normally, you will not be allowed to amend the pleading. That means when you are given time, you have to amend the pleadings. If you don't do it after 14 days or the fixed time, so you cannot file or you cannot get the pleadings amended. So no amendment of pleadings. And please remember, after the commencement of trial, regular trial, please remember. So this was actually stated in Usha Devi versus Rizwan Ahmad 2008 case also. Anyway, please remember, but there are certain cases where even after a preliminary decree, amendment can be allowed. This was made in AIR 1959 AP 26. Of course, in the interest of justice, to avoid further litigation, even a belated amendment could be allowed. These are all exceptions, please remember. So this was stated in Pankaja versus Yellappa, AIR 2004. So it is a cardinal principle that there is no injustice if the other side is compensated with certain costs. So normally the amendment of pleadings, please remember, should be in time, because already I told you that pleadings in general, they should be concise, they should be brief, and they should not be elaborate and whole form. As I told you, in order to, when you are framing the suit should have all the requisite qualities, of course, but we tend to forget the same. Therefore, the topic of amendment will come, but this amendment should be before the regular trial starts, but not after the framing of issues and other things better. So if you want to amend the pleadings, get it done before that stage itself, right? This is in general briefly regarding the pleadings, and pleadings are more important in CPC. Thank you.